Hello, my name is Hasha Akila. We would like to start this video by introducing administrative law and judicial review in brief, moving on to three different types of theories, two of which were introduced in the mid-1980s by Harlow and Rawlings. These theories are red light theory, green light theory, and rights-based approach. After understanding these theories, we will further go in depth with the current situation that is occurring worldwide in the United Kingdom and other countries around the world, and how they are handling this situation. We will then finish off by stating our opinions regarding the most relevant theories that should be applied in such events. The word administrative has no solid definition as it covers a huge area of meaning. However, administrative law covers public law, which includes the functions, powers, and rule of executive bodies of the government. According to Legal Terminology Dictionary, public law is part of law which governs relationship between individuals and government, and those relationships between individuals which are direct concern to society. Administrative has two main goals, which are to redress individuals' complaint and to improve the quality decision-making to the advantage of those who seek redress from government. Ultra vires is a doctrine of judicial review where there is a lack or excess of jurisdiction. In the infamous case of Council of Civil Service Unions and Minister for the Civil Service 1985, also known as the CCSU case, Lord Diplock introduced three heads of judicial review, which are illegality, irrationality, and procedural impropriety. When a public authority acts in one of these ways, the claimant may request for a judicial review application for the courts to scrutinize the action of legislative, executive, and governmental bodies to determine whether their actions are in accordance with the Constitution or not. So, what are these three grounds of judicial review mentioned by Lord Diplock? First is illegality. Illegality is when you fall under any of these: fettering decision, onerous conditions, discretion only partially unlawful, ultra vires, using power for improper purposes, taking irrelevant consideration or not taking relevant consideration, or unauthorized delegation. Next, irrationality. This refers to a classic case of Wednesbury relating to the unreasonableness where the applicant sought for judicial review as they argued that the condition was unreasonable and ultra vires the corporation powers. Lastly, procedural impropriety. This covers two major aspects, which, number one, the decision maker failed to observe procedural rules as stipulated in a statute or secondary legislation. Or number two, the decision maker has failed to observe the rules of natural justice or failed to act fairly. Remember the three theories I mentioned earlier? Now, let's begin with the first one, red light theory. It is also known as conservative normativism. It started in the 19th century. This theory is divergent compared with green light theory in aspects such as law, notion of control, and also liberty. It is similar with amber light theory, but we will not be discussing that today. Their theory limits the state's activities and powers in order to protect the individual. There are several beliefs that these theories hold. Theorists such as A.V. Dicey believes that the law has the freedom to govern itself or control its own affairs over politics. They also believe that the law must keep in check with the executive powers. A favorite way to do this is through rule-based adjudication in courts. Lastly, the goal is to enhance one's liberty, and this works best when the government is small. Courts will decide how the authorities should act. They cannot simply act however they want. The focus is on the court in making good decisions in running the country, and this is usually done during the time of peace. This theory is well known for the discretionary power that must be controlled. However, there are different theories regarding who should exercise this control. A case that applied this theory is in the case of H.M. Treasury and Ahmed, where the fundamental rights may not be overridden by general words of a statute unless by express language or with necessary implications.
Hello, my name is Jordan, and today I will be talking about the green light theory of administrative law. In contrast to the red light theory, which was explained previously, the green light approach believes that the purpose of administrative law is to encourage and ease the activities of the state. It generally limits the capacity of the courts and diminishes the presence of general standards. Greenlighters, they uphold the utilization of law as to encourage effective rulemaking and are more focused on an ideal government viewpoint in the administrative affairs. For those policies a government ought to adhere to, an administrative law is obliged to stipulate those policies as it essentially comes down not to withstanding judicial interference, but instead to make the policy effective and administer fairness for individuals. The policy-making framework wants to avoid the court's intervention with capacities provided by statutes, as this is to substitute in the court for the rightful decision maker. The green light concept begins from the perspective of a more positive, largely social and democratic view of the state. It developed from a utilitarian custom which suggests the concept of promoting the greatest good for the greatest number. As indicated by the concept, the state is relied upon in supplying a minimal degree of services such as education, social security, housing, health, and local amenities. In order to produce the greatest outcome for a large portion of its people, the state should bear a more comprehensive role. In other words, the state should acquire a broader authority. The green light concept widely encourages the development of policies directed at enhancing public service amenities. In conclusion, the purpose of the law is mainly observed as to endorse the procedures towards accomplishing public goal by the executive. Hence, it could be argued that this theory does not wish to derogate the rights of the people or to deny the values and aspirations of the democratic society. Furthermore, law is perceived as a valuable and empowering instrument. It can be seen as something very concrete and can basically issue the proper jurisdiction and foundation to govern collectively. In the sense of the green light approach, the law is regarded as a empowering or facilitative device as opposed to a limitation device which functions as a weapon to the authoritative body. Accordingly, the concept regards interference by the courts as a barrier to effectiveness. In upholding parliamentary sovereignty, the green light theory focuses on alternatives to the courts. Accordingly, in this theory, upholding parliamentary sovereignty in a country like the UK would enshrine the rule of law, where a matter complained of involves issues of high policy. The courts will decline to exercise a supervisory function over such decisions. Matters of public policy are for determination by the executive and not the judiciary, and any purported attempt to control these decisions will be regarded as a violation of the separation of powers. An illustration of this can be seen in the case of R. and Environment Secretary ex parte Nottinghamshire County Council, where the Wednesbury unreasonable test was unsuitable due to the context. It was held by the court that, although the state acts in welfare of the people, it is discretionary to provide some facilities in which the courts cannot interfere. Another example can be seen in the case of R and Cambridge Health Authority ex parte B, where the state decided not to fund in a potential life-saving treatment of a child as it was held non-justiciable even when the right to life is interfered. And the next part will be explained by Harsha, in which she will be talking about the rights-based approach.
The last theory we would like to discuss before going to the current situation that is occurring is the rights-based approach. Rights-based approach is related to one's right. Rights exist to ensure that everyone is able to live their lives peacefully, no matter of their ranks, and are protected from those who abuse their powers. There are a few characteristics that will be discussed. Firstly, rights are understood to be rights of individuals. Since rights exist to protect the essential needs and characteristics of human beings against those who wield public power, it is only correct for individuals to be the carriers of rights. Secondly, the foremost motive of public law is to protect the rights of citizens. The court's aim in performing a rights-based justice is to allow individuals to clear their names against those public authorities that uses their powers in an abusive way. Thirdly, this proposition provides the main jurisdiction for the exercise of judicial review powers. Judicial review is a must to ensure that those high bodies of law are also bound by these rights. Lastly, rights should be one of the aspects that should be considered during the process of judicial review. I would like to point out some cases relating to human rights. In the case of Commissioner of Police of the Metro Police and DSD and another, the two victims, DSD and NBV, brought a claim against the Metropolitan Police Service under Section 7 and Section 8 of the Human Rights Act 1998, as the police failed to conduct a thorough investigation. The claim succeeded and was awarded compensation. This is because the public authority had infringed Article 3 of the European Convention of Human Rights. Therefore, the woman was treated with inhumanity and was humiliated. Another case was regarding a patient that was given false information on the waiting time, which resulted him collapsing outside the hospital. This case teaches us that anyone or any public authority can be held liable when it comes to violating one's individual's right. The case I was referring to is Dalney and Colden Health Service.
Hi, I'm Gui Minchi. We have had a clear understanding of red light theory, green light theory, and right-based theory. Now we are going to move on to the most relevant theory based on the recent worldwide event of 2020. The outbreak of the COVID-19 was declared by the Committee of the World Health Organization, WHO, as a public health emergency of international concerns. On 30 January 2020, WHO called for an immediate response because there is no vaccines and strongly recommended that the virus should be addressed with extensive testing, tracing, and isolating. Currently, the UK has the Europe's highest COVID-19 death toll. Pursuant to Article 2 of the ECHR, confirmed that everyone's life to life should be protected by law. This has placing two substantive duties on the government, which are the obligation to refrain from taking life and to take appropriate measures to safeguard life. It is useful to look at some examples on the type of the situations where appropriate measures need to be in place. In the case of Savage and Assault, Access Partnership and H8 Foundation's Trust, where it was held that the medical authority must take appropriate measures to protect patient life are instituted, including having in a place suitable system of work. Also, in the case of art applications or Smith and Oxfordshire Assistant Deputy Coroner, it was held that the military authority must put in systems in place to ensure appropriate equipment is provided to soldiers to protect them from extreme temperature during service. Each of these cases was the case on particular fact, and importantly, the 6th division maker in question did not have to contend with an unprecedented pandemic. Nonetheless, the principle relevant to COVID-19 pandemic emerged with reasonable clarity which are the government or health authority must identify the risk of the death and put in place of the measure to mitigate the risk. They must adopt a proper system to protect life and employee. With this principle in mind, the following key policy decisions can appropriately be described as systematic issues in light of the recent worldwide event, thus triggering the duty to investigate the issues regarding the freedom of movement, quarantines and lockdown. Prisoners must now be released because the condition of the prison is so terrible with so many people gathering together, leading the virus to spread quickly. Some governments are aware of this and start to release some prisoners and immigrant detainees. Canada, Australia and Netherlands were all slow to act. The UK have planned to release up to 4,000 of the prisoners, which is 5% of the prison's population, but actually these were refused. In the UK, there is not only lack of actual release, but also disease prevention measures within facilities, insufficient masks, hand gels, and testing are reported. Legal actions against the leader in tracking the coronavirus outbreak in prison across England and Wales has been faced by the Justice Secretary Robert Blackland, Shadow Secretary of State of Justice David Lammy. Time is the essence to prevent our prisons from becoming COVID-19 hotspot. The Prisons Governors Associations has called for the prison's population to be released by 15,000. Two charities, the Hoover League for Penals Reforms and the Prisons Reform Trust, have just applied for judicial review. The charity wishes to call for faster action. Chief Executive of the Hoover League, Frankos believe Mr. Robert Buckland have recognized that the number of the people in the prisons must be reduced significantly so as to save life, but it cannot be achieved by the procedures taken by the government. More and more people are affected and the window and opportunity to protect people is disappearing. Peter Donson, director of the Prison Reform Task, criticized the government for not taking prompt action by saying the scientific and operational advice could not be clearer. If ministries are serious about following it, they must go further and do it now. Although there is judicial reviews and an expectations or that the detainee will be temporarily, immigrants as well as all criminals are only supposed to lose their liberty. Their bodies are meant to remain unscarred and intact. Given the pandemic, large number of prisoners must now be released. Shadow Secretary of State for Justice, David Lammy, also condemned there were still a number of issues regarding the quarantine and the lockdown.
Hi, I'm Samantha Tan, and I shall be continuing my teammates' presentation. So, since the court in UK is still pending a judicial review against the executive's decision to impose a lockdown, we could take a look at courts around the world and see which theory they seem to rely on and whether they are using rights-based approach, red light theory or green light theory. Well, we shall take a look in a second. Now we shall start off with countries where their courts seem to lean towards the green light theory with regards to the government's decision to impose a nationwide lockdown. For example, in A against Arden and B against Arden, this is a New Zealand case where the appellants are bringing an a judicial review against the president, well, not the president, I'm sorry, the Prime Minister of New Zealand, Jacinda Ardern, for breaching habeas corpus by imposing a lockdown detention for the whole nation. So in this case, the Court of Appeal dismissed both of their appeals and upheld the High Court's decision whereby the lockdown is not a detention because the citizens are still allowed to go out to get essentials for their essential needs, and this does not amount to a detention. So here we could see that the court in New Zealand are leaning towards the green light theory, where they sort of let the government impose this nationwide lockdown during this pandemic crisis in 2020. Now let's look at countries where courts seem to lean towards the red light theory with regards to the government's decision to impose the lockdown. In Malawi, the High Court judge in the case of S against President of Malawi decided to grant a 7-day temporary injunction, while the judicial review against the government's decision to impose a lockdown was still pending. Now, this means that the lockdown was lifted for 7 days and the citizens could still go out as usual during these 7 days. And this this temporary injunction was then extended indefinitely. Now it's important to note that this is not a judicial review decision, but it's still an act by the court that restricts the executive from, well, imposing lockdown. So it seems to lean towards the red light theory, where the judiciary restricts executive's decision. Lastly, we shall look at countries where the courts seem to lean towards the rights-based approach when deciding to situations regarding the lockdown. Now we could look at Germany for this. In Germany, a Muslim association was bringing a judicial review action against the government for imposing a blanket ban against all religious gatherings. Now, it's important to take note that this ban was during the time of Ramadan, a holy month for the Muslim. Here, the Supreme Court held that a blanket ban against all religious gatherings with no exception whatsoever is a cruel breach in fundamental human rights. So here we could observe that the courts are sort of leaning towards the rights-based approach, where they are focusing on individual human rights as opposed to collective human rights. With regards to the recent 2020 events, it is suggested that courts would lean on different theories depending on several factors, including public interest in their country's financial well-being, and also individual human rights. For example, if the country's financial well-being is more at stake than their health, then the courts would most likely lean towards the red light theory, as could be seen in Malawi. There were lots and lots of protests in Malawi by people who are not financially stable. And vice versa, courts would most likely lean towards the green light theory if the country has well and stable financial security to the point where this COVID-19 pandemic is of much importance than the economy at the moment. At the moment, courts around the world are forced to balance between the economy of the country and public health and safety whenever a judicial review action is brought up against the government for imposing a nationwide lockdown. Well, since COVID-19 cases are still quite high, it is more likely that the courts would lean towards the green light theory when it comes to lockdown, and possibly lean towards the red light theory when COVID-19 cases are much more manageable. But by that time, the executive would most likely lift the lockdown. Thank you very much. I shall let Jordan conclude our video.
In conclusion, the fundamental target of administrative law is related with the activities and limitations of administrative power. Administrative law, it concerns the framework, capabilities, and responsibilities of the bodies in the administration, in limiting their powers, and also in scrutinizing the procedures executed by them in utilizing their authority or functions. The red light theories are enacted on the state as to safeguard the people, and on the other hand, the green light theories are enacted to meet certain policy targets and decision making. Hence, based on the increasing needs of the society, following a restricted methodology by the judiciary would impair the standards of law. Therefore, considering the ongoing occasions occurring in 2020, an individual would more likely lean towards realism, functionalism, and utilitarianism as exuded from the green light concept, rather than positivism and formalism as exuded by the red light concept. However, in order to maintain checks and balances, the interference of the judiciary is reasonable in both of the green light theory and the red light theories. Thank you.